Hi Sondangale. Everyone is talking about latest March visa bulletin. So we just saw an 11-month jump in EB-2 for India, followed by talks about retrogression. And naturally, people are asking what's really going on. So instead of guessing or relying on WhatsApp forwards, today I have partnered with Manifest Law. I am joined by Gabriela Uriza, an immigration attorney at Manifest Law with almost a decade of experience handling business immigration, work visas, and talent visas. She has worked with some of the largest employer in the world. Thank you so much, Gabriela, for being with us today.
Well, thank you for having me, and I'm very excited to talk about the visa bulletin. We know there is a huge opportunity for a lot of people, especially your viewers, since now they're current and they might be able to file for their adjustment of status. So, very excited to be here today.
Thank you. So my first question is the big mark jump in visa bulletin. We saw a 11-month jump in EB2 India for dates of filing. So how significant is this? Uh, I believe this is because some of the travel restrictions for some countries still exist. So how significant is this?
It's huge, right? We haven't seen a movement like this in years. Like all other countries is current for EB-2 category, which again we haven't seen since November 2022, I think it was. And it is huge. It has a big significance because, like I said, thousands of people now who are living in the US and whose priority date is current under the dates for filing chart are going to be able to file for adjustment of status, a work permit, and a travel document. And this is very important, especially for Indian nationals, because as we know, Indian nationals have a very long wait on the visa bulletin, and some of them might be maxing out of their underlying non-immigrant status. And by filing an adjustment of status application and a work permit application, now they don't have to rely on an underlying non-immigrant status, right? Like they get protected as pending adjustment of status applicants, they're in lawful status, and they also have a work permit so they can keep working without having to worry about whether or not their H-1B is maxing out or their L is maxing out. So huge implications for Indian nationals.
Makes sense. So USA has confirmed it will use the date of filing for March. For those current on date for filing, but not on final action date, what is the number one benefit of filing I-485 immediately? Like, is it only the green card, or is it there any more strategic value?
There are a lot of benefits for people who are current on their dates of filing and are able to file for an adjustment of status, a work permit, and a travel document. And it's not just the work permit. So even though they're able to file for the adjustment of status, we know that they don't get the green card right away. They still have to be current on their final action dates, which is more delay. But the following benefits are, having the adjustment of status protection even if they run out of other underlying status. They're not accumulating unlawful status. They can remain in the US, filing a work permit so they continue working. They're not, they have restrictions. Like, for example, if you have someone on OPT, if they would get a work permit based on the adjustment of status, now they don't have restrictions on the type of employment that they can take. Filing for a travel document. As we know right now, visa stamping availability in India is very delayed. So having that travel document can allow someone to not have to rely on the visa stamp anymore. Also, you can gain portability benefits under the AC21 rules. If you have your adjustment of status pending after 6 months and you want to change an employer, you don't have to restart the PERM process or the I-140 process. You can just port that I-140 to another employer. And also, you get protection for children, right? Like many people, especially Indian nationals, have their families here and they do have children that are in school. So by filing the adjustment of status and including their children that are under 21, their age gets locked in, right? Because if they're over 21, then it's more difficult for them to be included in the family green card application. That's based on employment. So definitely that's the protection for children. And also you have a lot more flexibility in terms of planning for your life because you know that your stay in the US, it's protected.
Like, I just want to clarify on that one point. The kids getting protection, will that affect on date of filing, or is it on final action date? I believe they recently changed it. Is it?
So if you're in the US
Mhm.
and your date for filing is current, you're able to file your application and then include your derivatives, dependents, right? So your spouse and children under 21. If these children have a pending adjustment of status application, they file it before they turn 21, then they're able to continue with the process. Now, the age is a little bit more complicated because we also have another formula that you can use, and you have other moving pieces. So in terms of having a specific answer for someone that now has children, it is recommended that you speak to an immigration attorney, again, because of all the moving pieces that are happening. Even if you're not able to file with your children because they're going to turn 21 next month, there still might be an avenue for them to be included. But definitely it benefits them if they're able to file for adjustment of status and be included before they turn 21.
Okay. So, I mean, if someone's priority date becomes current for 1 month and then retrogress, what happens in that scenario?
So there are two instances. So if your priority date becomes current on their dates for filing and you're able to file, then nothing catastrophic happens, right? Like you lock in that adjustment of status application, your application moves forward, you have the work permit, the travel document. But if you don't file and you think, oh, it'll probably remain open in April, and then April comes and it's shut down, which has happened. Like we saw something like this happen back in 2018, a massive retrogression, you lose the opportunity to apply for the work permit. You lose the opportunity to apply for an adjustment of status. You lose the opportunity to apply for a travel document. So now you have to wait until it opens up, and it could take years. So I think that's key. Like nobody knows if it's going to remain open for another month. Nobody knows if it's going to close down and retrogress and be closed for years. Nobody knows. Like this has happened, like I said, in other years where it has gone back and people have lost the chance of applying for permanent residency.
Okay, so thank you so much on that one. So if you were a working professional coming to US in 2026, what would you do differently knowing today's immigration climate?
The first thing that I would do is start thinking about your green card process from day one. This is one of the biggest mistakes that I see foreign nationals make, that they don't have these conversations with their employers until after 3-4 years that they're living in the US. At this time, it might be too late to start a perm process, which can take up to 2 to 3 years. Start planning from day one. Explore EB-1 early instead of assuming EB-2, right? So especially for Indian nationals that have a huge backlog on their EB-2, start exploring EB-1. EB-1 might be a good option for you, especially for people that have an accomplished career. Another recommendation is build your profile for an O1 or EB-1A if eligible. If you're aware of the requirements for an O1 or an EB-1A from day one, you can start making career decisions that are going to position you in the best way to potentially apply for an O1, right? Like you make a better decision of taking a job, maybe accepting a speaking engagement, maybe publishing an opportunity of publishing an article. If you understand this criteria, you can start positioning yourself and making decisions that are going to put you in a good place. Document achievements from day one. Avoid waiting years before starting your immigration strategy. And I would also explore different avenues parallel to each other. And lastly, I wouldn't rely on an employer for immigration status. Again, a mistake that a lot of, especially younger people or students make is they think that because they're going to be working for a very large employer, they're going to sponsor them for everything, and they leave all their immigration planning on the employer, right? And then now we're seeing this year, these massive employers doing massive layoffs and leaving people stranded in the US not knowing what to do. So don't rely on an employer. From day one, start planning, start exploring other options. There are many green card applications that you can self-sponsor, and they are based on your achievement, not on a lottery.
Thank you. And this is regarding the prudential revocations. In past 10 days, I heard like 2 cases that they reached out to me. We are hearing about like prudential revocation among H-1B holders and even some H-4s. Okay, so is there a specific reason that this is happening? Like previously, I know that like if someone had some brush up with the law enforcement, or like they had a DU arrest, or like then their visa would have been like prudentially revoked. But the cases which I spoke to, they have no law enforcement incidents. Is there any criteria that like USCIS or like DHS follows to do this prudential revocations?
So as of today, we don't really have clear guidance on how the government is making these determinations of revoking these visas. But I agree with you. I'm hearing it more and more from H-1B holders, H-4 holders that never had a situation with the law, right? Like an encounter with law enforcement. And something to remember is that prudential visa revocation is a discretionary action by the Department of State. So they don't really have to have a reason and explain it to you. They can revoke a visa based on certain conditions or even suspicions, right? Without necessarily determining that the visa holder is ineligible. And something else is that the type of revocation is effective upon the person departing the US. So if you're physically in the US and your visa stamp got revoked, that doesn't affect your status. You're still able to remain in the US generally. However, once you leave is when you're not able to come back. Something else to keep in mind is that, like you said, like previously, this would happen in situations where a person had an encounter with law enforcement. Now we're seeing it more often without a reasoning. Some people, especially some practitioners, think that it might be because something related to social media, or let's say the person didn't provide all of their handles when they recently had an interview, or their name is similar to another name that was already in the system and had other issues, or previously one arrest wouldn't result in a revocation, but now the scrutiny is higher. So definitely speak to an immigration attorney that specializes in this type of cases so that you're able to inquire on why your visa stamp got revoked and the steps that you can take, because like you can agree with me, travel is essential, especially for a professional using an H-1B, but unfortunately we don't have clarity from the government on the reasons that they're revoking these visas.
Thank you. So is there any other topic you think that I could have asked you, like any other questions, or do you want to share any insight to the audience?
I think just a quick recommendation for anyone that's getting ready for the lottery, for the the H-1B visa lottery, that there is this misconception that employees don't have a lot of say or a lot of agency in the process, and it's driven by an employer. And sure, the employer is the one that puts the name in the registration and that handles the application, and the immigration attorney represents the employer, but there is a lot that the employee can do to increase their chances of getting an H-1B approved. And my first recommendation would be to, even if you're just putting your name on there, start working on gathering your documents. Don't wait until last minute to get copies of your diplomas or transcripts. And also, and most importantly, start working on a very detailed description of the duties that you take every day. I'll say about 30 to 40 full-time sentences. You want to show that your job is very complex and that it requires at least a bachelor's degree, and start making the connection between your education and those duties. Pick 5 to 10 classes that you took either during your bachelor's program or your master's program, and then do a paragraph for each class, making the connection. What do you learn in these classes that prepare you to perform these complex duties? Again, the mistake that I saw throughout several years doing CAP applications is that employees wait until last minute, until they get selected, and then they start running around trying to get documents or working on their applications, and that's why they don't provide a strong application, which could result in an RFE, further delays, or even denials, even though denials for H-1Bs right now are at all-time low, which is great. But again, there are a lot of things that you can do to expedite the process if you're an employee.
Okay. Thank you. Thank you so much, Gabriela. This was really good and nice, productive discussion. Thank you, as always.
Thank you so much.
Thank you so much.
Okay, bye.